Next case on the docket is Burkes versus State of Florida.
Police Court. I'm T. Hewlin Ray. I represent TERRAL Sean Burkes. This case comes before the court on motion to suppress in regard to his plea to the drug charges, and our issue before the court was whether a search warrant, which was lawfully issued, we're not arguing the probable cause aspect.
Let me ask you this. I found it interesting that neither side cited Hudson versus Michigan, the U.S. Supreme Court case that says that the exclusionary rule is not available for a knock-and-announce violation under the Fourth Amendment. And, of course, since then, a number of federal appellate courts have said that same holding, no exclusionary rule application applies to a statutory violation for the federal statute as well. Why wouldn't that case be decisive?
Well, that case came out late on, and
it came out about a month after the judge's ruling. But as I've looked at it, and I haven't researched it in depth, but every federal court that I've seen has applied it to cases that were up on review where the issue the case was not decided before the trial judge ruled, but obviously it was.
Well, I'm familiar with the case.
Okay.
And Hudson came out of Michigan, where they did not have a statute. The Michigan Supreme Court had ruled that the evidence in Hudson should not be suppressed, and the U.S. Supreme Court took certiorari on it. Now,
was the case here couched as a Fourth Amendment case?
Yes.
And under Article I, whatever section of the Florida Constitution, we have to apply the
not necessarily
U.S. Supreme Court's
interpretation
of the Fourth Amendment, correct?
There's two exceptions to Hudson in the state of Florida. One of them would be that there was a statute, 933.09, that requires that. The other is Article I.
But the statute doesn't give a remedy. In other words, the statute doesn't say
Correct.
that if there's a violation of the knock-and-announce provision of the statute, the trial judge is to exclude the evidence, correct?
Correct.
Okay.
But the other aspect of this is that Florida also has a constitutional provision for right of privacy, which is separate and apart from our corresponding Amendment 4, which is Article 1, Section 12, and the privacy one is Article 1, Section 23.
Has our Supreme Court ever applied the exclusionary rule for a violation of the right of privacy?
Oh, yes. They've done that in Spike Mike's telephone calls being made in the home, and there was no order for it. They've done it on several occasions. Yes, I'm familiar with that. So I don't see where that necessarily disposes of this case.
So your
as a matter of fact, there's a case.
Your argument would be that Hudson disposes of the Fourth Amendment claim, but not your claim that there was a violation of the Florida statute, because the Florida Supreme Court, or we could say, under our privacy clause, the exclusionary rule should apply, even though it doesn't apply on a Fourth Amendment analysis.
And since you brought up Hudson, and neither one of us has cited Hudson, there was a Spalding case that came out almost at the same time out of the second DCA, and they did not choose to have a rehearing or go back and change their decision. And that's the last case I've seen on the 933.09. Now, there may be in something I'm a country lawyer. I don't get them as quick as some people do, but I am familiar with that. My argument, if the court's not of the opinion that Hudson prohibits this, is strictly facts. The thing that we find here, pardon me just a minute, I'm going to bring on stuff up. I've had a problem with why these people didn't know that the police was out there. But if you look at the facts, what happened is it was dusk dark and the lights were on in the house. And on cross-examination of the defendant by the prosecutor, of TERRAL Burke, the question was asked, and the screen door, does that have any covering on that? And this is on the transcript, page 21, line 25, on cross-examination. And his reply was, yes, I think it's plexiglass. Now, you have a colored picture, which I don't have access to in mine. I've just got a little bright thing. But if you look at the transcript, page 194, it states Exhibit 1 is a picture of the house, and you should be able to determine whether or not this was what we in the Panhandle used to refer to as storm doors. I don't think it's a regular screen door.
Didn't the trial judge find that there were several facts that would have justified a no-knock entry in the case?
Well,
and it
the
looks
state only
like
argued one, and that's what we're getting to is exigent circumstances. I think if you look at the transcript and the testimony that was given, that the individual, and the only reason that the state argued was because somebody, their basic argument was exigent circumstances because somebody says there's a runner. If you look at the house, it's a very small home. And
there was testimony that there was a runner inside the house.
Yes,
there were circumstances.
and he was a fellow that was out about 20 feet from the house. Two or either four other officers that was entering the house said they could not see anybody. And we look at Officer Dwayne's testimony that he could not see anybody in the house until he got on the porch, and he did not see a runner. And it would be apparent that what Dietrich, I believe, is the one that either Dietrich or Frederick Holiday was a runner, was trying to create exigent circumstances so they did not have to knock. Now, the testimony was that they had information that there was a gun or guns inside. It turned out to be one. Certainly
that were drugs inside. Yes. And you have someone approaching who says that he saw a runner inside the house and yells out, "There's a runner, go in," or something to that effect. If that's the testimony and the trial judge makes a finding that there are exigent circumstances, that drugs could be destroyed, evidence could be destroyed, or danger to the officer because of the gun, now that someone's alerted, aren't we bound by the trial judge's findings if there's competent and substantial evidence to support that finding?
No, not if you read the record.
Are we supposed to disbelieve the witness that the trial judge believed? That would be improperly weighing the evidence.
You're supposed to apply the facts to the case to see if it's substantiated. And when you have one of the officers testifying, he did not see anybody attempt to destroy evidence, and then everybody was in this little living room whenever the entry team came in. There's no place to run. They had the house surrounded. There's anywhere from 20 to 30 people around the house, and 4 to 5 went in, and the lead team said they did not see anybody do anything, run, try and destroy evidence, and one of them said that he did not know of any specific peril that the officers were put in. So, you know, if the 933.09 is still to be applied, we have numerous cases that says that the officers, the entry team or the officers that are there to serve the search warrant cannot create their own exigent circumstances. So with those facts, I can't see where there was exigent circumstances. The people inside did not have any criminal history. They went through that, so they had no propensity for violence. and they testified the door was open.
I'm sorry, maybe I'm missing something.
I apologize.
Was there evidence that the officers on the outside knew exactly who was on the inside and knew that they lacked criminal history?
Yeah, the thing is, if you believe the testimony, they can see who's inside, and they've been told who was supposed to be there, and they undoubtedly could observe them. I'm just reading the record. I was not the counsel of record whenever this motion was made, and so therefore all I can do is read from the record that I have. And it indicates to me that there was an attempt on the officers to try and create exigent circumstances. Even though they say the door was open, they could see people inside.
Just so that I understand, is your argument that if law enforcement knows or believes, has a probable cause to believe that there are drugs inside and that there are weapons inside, and law enforcement sees someone who, upon sight of police, begins running inside the house, that is not an exigent circumstance?
If they actually saw somebody, yes. If they announce that and they're in position they could not see, no.
So your argument's not that the facts described by the one officer would not be exigent circumstances. Your argument is that the trial judge should not have believed that officer because it was conflicting testimony. Is that correct?
Because the entry team who was on the porch, Dwayne is the officer, testified that he did not see anybody run and that he was the first one in and everybody was in that immediate area. There was, I think his testimony was that there was a person that came towards him and he throwed his hands up, nobody scattered. And the record shows they didn't find anybody else anywhere in the house other than in that room. So this is a short distance, if you look at the picture, from the road to the house. This officer that yelled, somebody was running, says he was at least 20 feet away from the house. He's out next to the road because it's only about 20 feet to the house, according to what they indicated before. Now, like I said, I wasn't the one below, and I could ask a lot of questions had I been the attorney that was representing Mr. Burke below. But taking the transcript as is, it is apparent that there was an attempt to create exigent circumstances on a situation where the lead officer of the entry team, they could see that nobody was running. And this guy was standing out next to the road, and he hollered that. He said he's 20 feet away, according to the transcript.
Okay.
I have nothing else.
You have about 2.5 minutes left for rebuttal.
I'll reserve that in case I want to make a statement then.
May it please the Court. My name is Robin Compton, Assistant Attorney General representing the state of Florida in this case. The trial court made several factual findings in its order. First, that the wooden door was open. Second, that all the occupants were aware of SWAT's authority and purpose prior to the entry. Third, law enforcement had reasonable belief that the people inside were aware of their presence and also that the runner was attempting to escape or destroy the evidence. Based on these findings, the trial court ruled that even though the knock and announce statute was not complied with, one of the exigent circumstances applied, and the state submitted competent substantial evidence supporting these findings. First, SWAT announced out in the yard and on the porch, and one of the officers testified that there was no way that the people inside could not have heard the announcement out in the yard. Second, they had knowledge that the firearms were in the house, which it turns out they were. And the third and one of the most important things is this runner pops up. One of the officers testified to that. The runner pops up, takes off towards the back of the house, and the officer said that that's evidence that either he could be arming himself or attempting to destroy drugs. So based on these facts, the officers acted reasonably in entering without giving the occupants time to respond. So if there aren't any further questions...
In addition to that argument, do you believe that Hudson versus Michigan has any application in the case?
Well, I still think that the state still has to comply with 933.9.
Yeah, but the question is whether the exclusionary rule is a remedy if they don't comply.
Well, under that particular case, the exclusionary rule wouldn't apply. So if there aren't any further questions,
Thank you, counsel. Any rebuttal? Thank you, counsel.